All right, good afternoon, everybody, and welcome to the MSHA and OSHA Silica Regulations and Enforcement webinar provided for the Illinois Aggregate Association of Aggregate Producers members. So thank you to everyone who has joined. I will be your presenter today. My name is Nick Scala, and I am the chair of the MSHA Litigation Practice Group at Conn Maciel Carey, and we are a firm based out of DC, but work with companies all over the country and are an IAAP member. So really appreciate the opportunity to speak with you guys today on this interesting topic, and appreciate that opportunity. So thank you for logging on. So as we talked about, we're going to look at what is the OSHA and MSHA Silica enforcement or Silica regulations, and we'll kick that off with going through MSHA first, and then we'll touch on the new construction regulation which went into effect for the OSHA Silica rule just in the past couple weeks. So there'll obviously be a lot of different information we can cover, and we'll do our best to cover as much as possible. And as I said before, if there are any questions on follow-up, please feel free to contact me. So when we look at the metal non-metal regulations for silica exposure, when we're talking about MSHA here, we are looking at primarily three standards, and that is 56, 57 in the CF section of the CFR, 30 CFR, 5001, 2, and 5. And we're really looking at that because 5001 is the standard which implements the threshold limit value or incorporates the threshold limit value for MSHA on silica. And it does that not specifically by enumerating the standards or the limits in that standard, but by incorporating a document from the American Council of Industrial Hygienists back in 1973, where they put out a lot of different permissible exposure levels or threshold limit values for certain types of chemicals and substances, and one of those being respirable silica. The second regulation that we see oftentimes cited with this condition is going to be 5002, which is exposure monitoring. And given that this is a shorter regulation, I included the text below it, but just dust, gas, mist, and fume surveys shall be conducted as frequently as necessary to determine the adequacy of control measures. So that is a very vague regulation in terms of how often you need to conduct these tests, and as frequently as necessary often results in MSHA being able to issue citations for this standard whenever they find an over an exposure, especially if we don't have a robust history of testing for that particular task or that particular job duty. We can see citations for this failure to monitor as much as necessary. And again, this does not just apply to silica. It applies to many other substances, as do the other two standards we're looking at. As we can see, this 5001 is just for exposure to airborne contaminants. And like I said, it incorporates those limits from that previous document, and so that includes a number of different substances. And oftentimes when we see, again, MSHA's lack of regulations on confined spaces, if we do see citations coming from that work environment, they are often going to be citations that are issued under these exposure standards. In addition, the third regulation that we really look at when we're talking about MSHA citations on silica exposure is the control of exposure to airborne contaminants. And this particular standard looks at what are we doing to prevent exposure, to control exposure in terms of controls such as administrative controls or engineering controls. It also gives us the language that we see that respiratory protection can be used as a form of limiting exposure, and you won't receive the citation only if all feasible engineering controls are exhausted. And I specifically bring up that statement, that comment in the first part of that standard, because all feasible engineering controls, that's a very, 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 very high bar that MSHA has on that. So, when we have to look at it, or if you get a citation for this, when we're looking at abatement, there are very limited circumstances when MSHA is going to, allow you to say that all feasible engineering controls have been implemented, and therefore we are going to be able to use a respirator to get around this exposure standards. And really, when they're looking at that, they're looking at closed environments. So, such as a bag house, somewhere where they know the threshold or know that the exposure limits are going to be well exceeded, but we have made a self-contained environment, and we've limited the environmental impact or the atmospheric distribution of silica dust, respirable silica dust, for our purposes today. So, when we're talking about all feasible engineering controls, MSHA has a high bar, so, when we look at that, we don't want to get into a situation where, oh, well, we replaced all the guarding, we patched up all the holes on this that maybe were resulting in a leak. We can't do anything else to remove this source or to correct the exposure problem. That's not going to be sufficient if we're in the process of abating a citation. MSHA is going to also look at, changing work practices as well as engineering out the problem altogether. So maybe going upstream and putting in different types of controls that will remove the respirable silica dust as being a contaminant that can get into the atmosphere. This standard also includes language on what we have to do in order to comply with MSHA's respiratory protection requirements, and it really just points you to the ANSI requirements that we have to apply. It also is going to discuss what are going to be permitted or acceptable respirators. So, typically if we are getting citations for overexposure under the Mine Act, we, see the citations are issued as a violation, or when we see the standard cited, it will be some combination of 5657.5001, and it can even be a combination of 5001 and 5005 if they don't believe engineering controls were implemented and that was the cause of the exposure. But these are really the meat and potatoes of MSHA's silica enforcement regulations. As you can see, we have in MSHA 3 discrete regulations that really cover this hazard. And, as we'll see later, and as most of you, if you have OSHA concerns or OSHA jurisdictions under your control, that standard is voluminous. It has many subsections. It's detailed about all the requirements. We don't have that with MSHA, and you'll find that in most different types of standards with the Mine Safety and Health Administration. They're vague. They're very vague. They're very broad in how they can be applied and how they can be interpreted. And, that is in part by design with the Mine Act and the discretion that the agency wants to apply them how they see fit. So when we are looking at the silica exposure, we're really looking at these 3 citations. This is what we're going to be likely to have a violation under or a citation under. And we'll talk about it a bit, but, these are very hard citations to defend if we want to contest them. And we'll talk about some ways where you can set yourself up a bit better, but if we want to contest a citation for silica exposure, we really need to lay that groundwork early. We need to have that protections in place. We need to have our testing and our policies in place so that when we do get a citation, we have that mitigation, or we have the defensible documents and the defensible information already in place. Because if you don't have any of this in place and you do receive a violation for overexposure and we don't have any of our own test results, you're really at the mercy of MSHA being the only one with information. And, we talk about that. If you've been on, any webinars or most likely heard any, MSHA attorney speak in the past, we encourage you guys to make a record of your inspections, make a record of the alleged violations so that you can contest them and you have your own information to go off, so we're not just being controlled by MSHA as the only source of that information that is contemporaneous. And that's even more so applicable to the Silica regulations, because this is going to be based on data collected, test results collected. And if we don't have, a companion sample that was taken at the same time, or we don't have a history or a recorded history of our exposure as certain tasks demonstrating that this was not an area of concern, we really are going to have a hard time challenging those citations. So one part of complying with MSHA's respiratory requirements is the implementation or the creation of a respiratory protection program. And if you are going to use respirators on site, if they are going to be required, you need to have a respiratory protection plan. And, this is really a document that is going to outline employee training, how you're going to use respirators, what your procedures are going to be for using respirators, evaluating workplaces as hazardous or determining that they are going to require a respirator to be used. It will include provisions regarding evaluation of individuals for even being fit to wear a respirator, because we have to keep that in mind. We can't just throw someone in a respirator and put them to work. They have to be determined that they are physically able to work in a respirator. These are, constrained environments. It does really affect your breathing. It does affect your ability to work. And so we have to be careful not to put someone who might have health issues or might not be physically fit enough to wear a respirator. We can't just throw them in that and put them out in the workforce. We have to be able to provide a medical evaluation that says this person is physically able to wear a respirator. As part of that, we will also need to fit test an individual, which means we have to determine that the respirator is properly fitting the face and therefore preventing the airborne contaminants from getting in. And these are all the initial steps, but they have to be part of our respiratory protection plan. Including in this, we have to train individuals on how to use the respirators, how to properly maintain them, how to store them. We want to keep a record of the exact model and size respirator that individuals were assigned. We want to keep a record of the date the tests were taken, the method that we tested. We also want to, maintain these records as part of not only our training documentation, but as maintaining them as part of our respiratory protection program. It is probably a best practice if we are frequently wearing respirators to assign one per person. Then you can, manage who's taking care of the respirators. Do these people need to be retrained or reminded that they are required to store them properly, to keep them in good working order? We also want to have written policies and procedures in this on how to work in certain areas and work practices that may, or work tasks and jobs that may be affected. A lot of this is evaluating where the risks exist and determining where maybe even that respirator does have to be used or is required to be used by you as a company. So this respiratory protection plan, it's really the starting off point, especially if we're going to require individuals to wear respirators on our site. It is a document that MSHA can and will request. It is also a document that has to be created in abatement of an overexposure citation if we don't have that in place already. This doesn't just apply to people that know they have a silica exposure problem. It can happen to anyone who is getting that health sampling conducted by MSHA on site once a year. And if a company that's never had a history of silica exposure before or doesn't believe that they have any exposure to silica for their workers, if they're found to be overexposed, they're going to have to create this respiratory protection program in order to abate those citations. So when we are looking at the silica exposure and testing, we're looking at the threshold limit value. And what does MSHA look at for the respirable silica threshold limit value? And that's 100 micrograms per meter cubed. And that means that over the course of the day, and your 8-hour shift, or if your employees work for 12 hours, they are going to be monitored by MSHA for 12 hours. And then that calculation resorts back to what is their exposure limit during the entirety of their shift. But this number is, it is your threshold that you can't go above. And it's going to be calculated by looking at the amount of respirable dust that is breathed in or in the breathing area, the percentage respirable silica or respirable quartz in that respirable dust. And, it can, because of that, if you are an extremely high percent of respirable silica, you can have someone over the TLV in 15 minutes. Where if you are in a low area, if you don't have a great percentage, or there isn't a significant concentration, you might be able to work for 8 hours. So that's, something we have to keep in mind. And it's also something we want to keep in mind when individuals are working in enclosed environments. So maybe we have a processing facility that's indoors, and it's normally fine, but if a leak springs, your guys could be overexposed immediately, and you're going to have to take some action to correct that, whether that is going to be, the repair, the shutdown in order to complete any repairs. We need to look at those kinds of options when we're talking about avoiding this threshold limit value. As we talked about before, the sampling will take place by MSHA once per year. This does not and cannot be counted as your testing. If you want to test at the same time as MSHA, that's fine. And that's an important element that you do have that right. If you want to schedule your testing the same time MSHA comes out, you can do that as long as you don't have any reason to believe that testing more than once a year is necessary. But your results or your records cannot be the results that MSHA provides. It is important that if you receive a citation on silica exposure, you're not necessarily going to get the detailed records and the lab results from MSHA. If you want to get those, if you want to compare your lab results, if you want to compare what those numbers are, you're going to have to file a FOIA request on those documents, and you can get them that way. As I said, the samples are taken the entirety of a minor shift. So if that is 12 hours, MSHA will sample for 12 hours. If it's 8 hours, et cetera. You can limit exposure or attempt to limit exposure by reassignment of job duties, or if you have an area that there is more of an exposure risk, you can limit the person's time or the miner's time in that specific area. This is permitted by MSHA. If we have a citation issued at this point in time, what we've seen, the trend is that MSHA is requiring both engineering controls, or primarily engineering controls, to reduce exposure in order to terminate the citation. It won't just accept shifting around work schedules, because that is an administrative control. But in order to avoid even getting a citation, we can adjust work schedules in areas that we know that could be a possible exposure issue in order to keep people below that threshold limit value. One area where people sometimes get in trouble is when MSHA does come out and issue a citation. Maybe we're having a 12-hour shift. We can't just shift to an 8-hour work time in order to abate the citation and then go immediately back to 12. MSHA won't take this as a proper sample or a representative sample of the working conditions. They're going to want to look at that shift as it is. And now, it is your right to change your shifts however you see fit, but you can't do it just in order to abate a citation or to avoid a citation by MSHA. If you always work 12s and MSHA shows up and you decide to work an 8, that information, you might get away with it once, might get away with it twice, but eventually MSHA can come back with that, and they're going to really come down on you guys hard, and we don't want that. And that's also not how we should be trying to maintain compliance. We need to look at a way to maintain compliance during our normal work procedures. So what happens if we do get a citation? What should we be looking for when we're trying to evaluate, should I contest this, or is this a properly issued citation? Well, MSHA luckily gives us some pretty good guidance on how they're going to issue citations for exposure. And, when we're looking at it, obviously we know that citations have the element of gravity and negligence. And those are typically the most important. Those are typically where we see citations go from, very benign to, whether it's low negligence or non-SNS to the more severe citations. And part of that is looking at your negligence, looking at how MSHA is going to evaluate that. And, really we should look at these and we should read them as, could this possibly go into the realm of unwarrantable failure? Because we want to defend against citations, obviously, at all times, but we most certainly want to defend against an unwarrantable failure. We don't need those 104 Ds. And also, if we're getting Ds for exposure, and we get that D order after that initial D citation, every one of those is a withdrawal order. So that entire area of the mine could be shut down until we get a passing test. And that is an important element of this. So, these tests aren't immediate. MSHA will do the health sampling, and you might get the results 3 weeks later. The same goes for termination. So we want to avoid these 104Ds. We want to avoid getting shut down over these because there's a long lag time with getting results. They're not going to come out tomorrow. You might not be able to fix the condition tomorrow. So you want to be able to satisfy these criteria or not satisfy them in that, if we knew or had been told of high contaminant levels, we want to have taken action. We don't want to have been told that this was an issue and then do nothing. That's how we get higher negligence and warrantable failures. We want to maintain our engineering control systems if we have them. We want to make sure that they are in good working order, that we're not ignoring repairs and maintenance on them, because that's going to be taken into consideration. Another consideration, if the condition is widespread, is going to be, where are we at with it? Have engineering controls even been provided, or are we simply relying on administrative controls to reduce exposure? And then also, if, did we provide respiratory protection, and if so, did we train people on it? Did we fit test if proper? Did we encourage our individuals to wear them or require them to wear the respirators? How are those stored and maintained? These are all going to be going into negligence on the company. So we want to be able to provide that information. And again, this should be satisfied when we look at our respiratory protection program, that we are evaluating our workplace for these hazards if applicable, and that we are continuing to monitor and provide the necessary protections to our employees. But when MSHA is going to issue a citation on this, they're going to look at these factors in determining that. Another important part is, are these citations going to be S&S? And MSHA gives themselves a good bit of leeway in most aspects about when they can issue what. But this one is actually, pretty clear-cut for MSHA, and it states in the orange part at the bottom states that, a citation should be unlikely if the appropriate respiratory protection was being worn, was appropriate for the hazard, and the respirator was fit tested, and they had an acceptable respiratory protection program. So even if we get an overexposure, if these elements are satisfied, it should not be an S&S. And that's important to remember because, even, as I said before, even if we get an S&S citation and we don't have any results to challenge that reading, this is one of those elements where you can lay the foundation early on for getting off an S&S. Did we have the training? Did we have the program? Did we, encourage or have our people wearing them? Now these are all important. And we see that up above it tells us, different areas that we can be at the highly likely or reasonably likely category. And, it's important to note that most of these are going to be listed as fatal because MSHA sees silica as a silicosis as a fatal disease. So, if we have done these actions, we should be looking at non-SNS citations. One area that some MSHA inspectors seem to get a bit out of hand with is facial hair when you're wearing a respirator. And, the requirement that miners cannot have facial hair when wearing a respirator, that's not the entire story. Miners can have facial hair, but it has to be limited to something that does not affect the face to mask seal, meaning, you have to have a properly trimmed, whether it, could be a mustache that is within the respirator itself. You can have those as long as they're not affecting the seal. And if you're fit tested with that condition, it should be noted on those fit test records so that we can, prove to MSHA that the person had a mustache when we fit tested them. It didn't affect, they still passed, this is fine. But, also, though, don't let MSHA try and say that just because someone had facial hair, they weren't wearing a respirator, because that's not necessarily true. Obviously, if someone has a big, full beard that, maybe it's not even going to be helpful to wear a respirator. But, we want to make sure that if MSHA is alleging that, we have some evidence of, what the facial hair situation was for those individuals, because, we want to be able to prove that, no, this was not as bad as MSHA thought, or no, this wasn't as prohibitive to the effectiveness of the respirator. So just a couple areas where, we see some challenges with MSHA. So again, if we're going to get citations in here and we want to contest them, as I said before, it's difficult unless we take the actions beforehand to lay that foundation. We want to actively monitor exposure at our sites if we believe it's a concern, if applicable. We also want to have the proper training, policies, procedures, respiratory protection program. We want to have everything that aligns with what MSHA requires, and even goes above and beyond if that was what our company wants to do. We want to maintain those records, whether they're training records or they're records of fit testing, or the medical records stating that people are permitted to wear the respirators. We want to maintain those. And, this is a best practice, but if MSHA comes out on your site and is performing sampling, and you're a company that, has the ability to do your own testing, meaning you have your own cyclones on site, attach them to the miner as well. You're permitted to do that. MSHA can't tell you can't do it. If the inspector tells you that you can't do a companion sample, call their field office supervisor or call the district, because that's untrue. You can. This isn't going to immediately get you out of a citation if, MSHA has a result that says you're over and you say you're under. MSHA is not going to accept that. They will rely solely on their results. But if you really want to contest it, a judge will look at that. And especially if we have a history of testing, if we have a series of results that show that we are under, that's going to be very persuasive to a judge. Instead of an outlier MSHA test that was taken at a single day in a year. So that is something to, some tips on how to possibly avoid or challenge these citations. You all are up in the North Central District with IAAP, and, this is an area that there's been quite a bit of activity in the North Central District on, silica monitoring. And so you want to keep in mind, you want to be prepared for that, and you want to be prepared to contest, to move forward, to abate, all in a timely manner. And so, that's when I say when we're looking at abatement especially, don't let this carry on. MSHA, the only way they can abate a silica standard is to do their own testing. Our testing won't, terminate a citation. So we want to make sure that before they come out there that, we've reduced that exposure level, that we've removed the sources. so that we're sure we're going to pass it, because we don't want to let these lay open for months and months and months. That's not going to do us any good. And as I said, MSHA doesn't come out and do these all the time. They then have to send the samples away. So, these citations can linger a lot longer than other MSHA citations. And until they're terminated, we can be bound whatever MSHA wants to require us to do. I had a client in the South Central District who, their mechanic got tested over. They've never had an issue of silica exposure at any point in time. And until MSHA conducted a test, he had to wear a respirator at all times on site. And so we don't want to have to do that if it's unnecessary, and if we do have to do it, we don't want to do it longer than we need to. So, that's a quick overview of what's going on with MSHA on silica. If you have any questions on it, please let me know or give me a call. We can talk about that. But I know a lot of people are interested in the new OSHA silica regulation, especially for the construction industry, which just went into enforcement and effective, or was just able to be enforced on October 23rd. So, the general industry and the maritime provisions, that's still out for a year until June 23rd, 2018. But the construction industry, that is now enforceable on the silica standard. Now, this is still being challenged legally, but, we're not going to get a immediate result that way. And also, if they were going to issue a stay or an injunction on enforcement of the rule until legal proceedings were decided, that likely would have already happened. And so with that, OSHA is now able to enforce on the construction industry their new permissible exposure limit of 50 micrograms per meter cubed and their new action level of 25 micrograms per meter cubed. Now, this is a big change in terms of what was permissible exposure. As I put there in orange, the previous PEL was 250 micrograms per meter cubed for construction. So we're at 20% of that. That is a very, very significant decrease in what we can have employees exposed to. So, this is a very detailed rule. It's not just a couple sentences that refer to another piece of literature like the MSHA rules. This is a detailed rule. I'll try to get through as much of it as I can before the end of the webinar, but we're going to hit the highlights. And, part of that is this now is going to require employer assessments to determine if employees will be exposed to levels of respirable silica above that action level. So above that 25 micrograms per meter cubed. And if we are going to have people that are going to be above that, we need to start implementing a lot of the requirements from this regulation. If we, test and get below that 25 micrograms per meter cubed, we're not technically out of the woods, because the reading of the regulation says if readings below the action level and will not exceed the action level under any foreseeable conditions, the employer need not take further action. So if we determine that our work environment is not exposed to levels above the action level, we also have to make sure that under no foreseeable conditions are we going to be above that action level. And so that's a pretty high bar. That's really looking at operations where respirable silica isn't even a concern, because this 25 micrograms per meter cubed is a very, very low level. That's 1/10 or 10% of the previous PEL. And any foreseeable conditions, that's a very, very broad definement, or a very broad requirement that OSHA puts on individuals for determining when they have to, take action in accordance with the action level. So, how are we going to comply with this? First off, for the construction industry, OSHA created what they're calling Table 1. And this was specified exposure control methods when working with materials containing crystalline silica. And this table, and I put a link to it in the presentation, so when you all get a copy of this, you can just click on that link. But and this is the standard number that it's listed at, that 1926-1153 C1. But what this includes is specific tasks such as using masonry saws, power saws, drilling rigs for concrete, crushing equipment, tasks such as that where OSHA determined that it's likely to result in potential overexposures. What this Table 1 does is it gives you engineering or work practice control measures, and if you follow these and fully and properly implement these exposure control methods, this task won't be subject to OSHA testing, and also you won't be required to conduct your own testing. It will give you a series of tasks that if you implement their controls and you provide the respiratory protection as they specify, you're going to be exempt from the other requirements of this enforcement, or taking the other types of exposure control methods. So, I encourage you, if you are going to have people engaging in, anything that might be, one of these predetermined activities, such as jackhammering and chipping tools, heavy equipment that is used during demolition activities in areas where that might be, silica might be present, excavating or grading where silica might be present. These are areas that you want to look at this, look at what OSHA has already determined are adequate control measures, which might be, adding water to it. And then also comply with when they are determining that a respirator should or should not be worn, which they'll look at, is the person going to be exposed for more or less than 4 hours, and then tell you, if a respirator is required, and also, if so, what type of respirator they want them to wear. And again, and this is how OSHA defines it, or the language they use, but fully and properly implement the engineering controls, work practices, and respiratory protection listed in Table 1, the company is not required to conduct exposure assessments or otherwise comply with a PEL for employees engaged in those tasks. So we definitely want to take a good hard look at this Table 1. It's going to be an important tool for us if we have individuals who could be exposed. If we are dealing with tasks not included in that Table 1, then we're going to have to start doing an assessment of our exposures. And what OSHA gives us there is 2 options on how to determine our assessment and to test the exposure. The first one is going to be the performance-based option, and that's going to look at what task is taking place. Is there data out there for that task that is objective data, means such as industry-wide surveys or calculations based on the composition of the substance, or do we have representative data from individuals doing this task at our job sites or within our company previously? That is data that we can be used to satisfy that performance option, or and determine if we're going to be above or below. And also the other one is scheduled monitoring, and that requires that individuals must perform monitoring as soon as work begins on a task to determine the exposure level and whether or not we need to start implementing controls. And the other one is, we have to do it at some kind of specified interval. That's the second part of the scheduled monitoring, to determine if that has changed, if the exposure has changed, and if we need to start initiating more control options. If we have multiple people performing this task or performing the same task, we can do a representative sample of a group of employees to meet the requirements. So we don't necessarily have to do everyone's testing if we have a group of people doing the exact same thing. but the person that you have to test has to be the employee that is expected to have the highest exposure. So they want to make sure that if you're testing only one person as a representative sample, we're testing at the highest limit and then going down. So, you know, if we are finding that we are going to be above that action level, we need to start implementing a written exposure control plan. And, you know, this has to be, once it's created, it has to be reviewed annually and, you know, at that point in time, updated or modified accordingly. We have to be able to provide this to, you know, OSHA if they come on site, along with employees and employee reps. You know, some of the specific elements that we need to include in this is, you know, a description of the tasks that involve in exposure, description of the engineering controls or work practices, and the respiratory protection we're going to use to reduce that exposure for employees, as well as the housekeeping practices we're going to use to limit that exposure as well. So, you know, another part of it for construction industry is the competent person. And, you know, for mining, we are probably familiar with this, but, you know, the competent person has to be someone who is capable of identifying existing and foreseeable silica hazards in the workplace. They have to have the authorization to take corrective measures or prompt corrective measures to eliminate or minimize the hazard, and they have to have the knowledge and ability to fulfill this duty. Another part of having a competent person assigned is the other construction employees on site have to be able to identify the designated competent person. So, you know, competent person from the mining side, we're used to seeing that in reference to workplace exams, right, or with our training, and we determine the competency. Much the same, if our competent person can fulfill those, you know, qualifications that, you know, I just mentioned, they can be listed as a competent person as well. But, you know, we also have to make sure that everyone is aware of this. In terms of housekeeping, this has been a big area that we've had a lot of discussion, or that there's been a lot of discussion on regarding this standard. But, you know, we have to remember that it prohibits dry sweeping or dry brushing if that is going to create more of an exposure issue on crystalline silica. So if we are going to take housekeeping, you know, it encourages using water as a significant method to reduce exposure or reduce making that crystalline silica airborne. We also, you know, are going to be able to use compressed air, but in order to use compressed air, there has to be a ventilation system that effectually captures that dust. So we can't just go around spraying everything off with a compressed air hose, but if we do have a sufficient enough ventilation program that will suck up all that respirable silica, that is another method. We can also put different compounds on the ground in order to sweep that is going to keep dust down. OSHA suggests, you know, oil or wax-based supplements. But, you know, those are just a couple of the elements that OSHA specifically mentions as means of completing housekeeping. Obviously, washing things down with a hose altogether is a method to keep that water or that dust suppression in place while we're doing housekeeping. But these are elements that have to be included in our written exposure control plan, because housekeeping is often the most significant or one of the most significant areas of exposure. So another part of this that people have had, you know, quite a few questions with is going to be the medical surveillance. So, you know, in order to determine if medical surveillance is required, we must evaluate if an employee will be required to wear a respirator for 30 or more days a year. And, you know, that does not include any time, you know, if someone has been hired from another company and maybe they had to wear it 15 days there, you're not working with the 15 days at your employment. It's 30 days at your place of employment. The flip side of that, where you don't have to include other exposure days or other respirator days at a former employer is even if someone just wears a respirator for 1 hour that day, that or less, just for a short task, that's going to be considered a respirator day. So if someone wore it for 30 minutes to perform a cleanup, that is 1 day of those 30. We don't have to add up the hours that they wore it for 8 hours, now we're at day 1. Or 16 hours, now we're at day 2. If they wear it for 30 minutes on day 1 and 15 minutes on day 2, we're at 2 days. So that's an important element of that. We have to, provide at no cost to the employees the medical exam within 30 days of an initial exposure. That is unless they were provided with an exam within the last 3 years. So there is another kind of carve out there for people who are previously in this program. We also have to provide follow exams at least every 3 years, or more frequently if that's determined necessary by a medical professional. And we have to maintain a record of all of these surveillance visits and of their record of that happening. The exam is going to consist of reviewing their history, and that's going to include smoking history, work history with crystal and silica. It's going to include chest x-rays, pulmonary function tests, physical exams. So it is going to be a pretty in-depth test. There is a written report that's provided, and it will be limited, but it will provide recommendations if there's limitations that the employee can use a respirator or limitations that they can be in or around crystal and silica. That's going to be included in that. There's also the opportunity for an employee to sign a written release, which will provide additional information from the doctor to the employee. But that is obviously going to be something that we have to get that release signed by the employee so that we can get that additional information, because OSHA is trying to protect the employee from having too much information about their medical history in the records of the employer. So, another significant element is the communication of hazards and training. Any person who could be exposed needs to be trained on the hazards of silica. This includes being provided copies of the, MSDS or GHS forms, FDSs. It includes training them on the tasks that could expose individuals to crystalline silica, on the work practices to limit, on measures we've taken or implemented to protect it, and whether that's going to be engineering controls and work practices. And also part of this is going to be who is the competent person designated to do the inspections and to provide that information and take immediate action to correct those hazards if there are any found. So in terms of what we have to do, there's obviously going to be a lot of new requirements. We're at the point now where we've been talking about this rule going into effect for a number of years, and now it is in effect for the construction industry. Now they can come out and enforce it. It was initially sent to come out, you guys know, in June. They did a 3-month delay until September 23rd. Then they did an additional month delay where they would cite but not assess penalties. Now we're out of all of those. We're in, normal enforcement for the purposes of OSHA regulation of this new rule. And, that is obviously going to carry with it a lot more in terms of requirements. And, we have to remember that this is engineering controls over any type of administrative control rule. Just like MSHA is focusing on that, focusing on administrator or engineering over administrative controls, this rule requires it. The OSHA rule requires it. And, back when this all started, OSHA said that they wanted to have a technology forcing rule, meaning that it would require people to create new ways of doing things, new technologies in order to reduce silica exposure. And, so we have to keep that in mind. We're not going to get people out of this by limiting work shifts or by slapping a respirator on them. They're going to want, in order to abate, in order to terminate citations for both agencies, they're going to want to see administrative controls put in place. Engineering controls put in place, So, we want to keep that in mind. We also want to keep that in mind when we're looking at what we're doing in order to make corrections proactively. Obviously with MSHA, we're going to see them at least twice a year, 4 times if we're underground. With OSHA, you're not guaranteed to see the regulatory body, but nonetheless, we need to take steps to comply with this standard so that if that time comes, we're prepared. With that, I want to thank everyone for joining us. I'm happy to answer questions if you want to send them in or contact me. Again, you guys all know, but you can check out the blog that we maintain over here, as well as we have a couple more MSHA webinars coming up this year that you can join for free. But yeah, if there's any questions, I'm happy to take them. I appreciate everyone jumping on today, and thank you for your time. And if not, we'll hopefully be able to have another webinar in the future. So if you have any ideas on topics, please relay that to the safety committee, and we can hopefully get that put together for you. All right, it doesn't look like we have any questions. So if anything comes to mind after you've sat down and listened to this again or reviewed the presentation, please feel free to contact me. Appreciate everyone jumping on. Thank you.